The idiots have been in charge way too long. And that's why you're here. For the podcast you need. All for liberty all the time. Welcome to Liberty Bites Back. With your host, Brandon Imel.
The right to privacy, it is an inalienable right. The U.S. are through state rights, granted within the United States, who also grant a right to privacy and recognize 4 torts based on that right: intrusion upon seclusion or solitude, or into private affairs, public disclosure of embarrassing private facts, publicly, which places a person with a false light in the public eye, appropriation of name or likeness. The United Nations even notices the right through their Article 12. It reads, "No one shall be subjected to the arbitrary interference of his privacy, family, home, or correspondence, nor to attacks upon the honor and the reputation. Everyone has the right to the protection of law against such interference or attacks." The Fourth Amendment to the Constitution of the United States ensures that the right of the people be secured in their persons, houses, papers, effects, against unreasonable searches and seizures, shall not be violated, and no warrant shall issue but upon probable cause, supported by the oath or affirmation, the particularly describing the place to be searched and the persons or things to be seized. The Fourth Amendment, as the framers attempted to protect each citizen's spiritual and intellectual integrity. A government that violates the Fourth Amendment in order to use violent evidence against a citizen is also violating the Fifth Amendment. The First Amendment protects the right to free assembly, broadening the privacy rights. Some believe that the Ninth Amendment declares the fact that a right is not explicitly mentioned in the Constitution does not mean that the government can infringe on that right. And the Supreme Court recognized the 14th Amendment as providing a substantive due process right to privacy. And that was first recognized by several court justices in the Griswold versus Connecticut in a 1965 decision protecting a married couple's rights to contraception. On August 22, 1972, the Alaska Right of Privacy Amendment 3 was approved with 86% of the vote in the support of the legislatively referred constitutional amendment. 25, Article 1, Section 2.2. This would be Article 1, sorry. Constitutional Amendment, Article 1, Section 2.2 of Alaska's Constitution states, "The right of the people to privacy is recognized and shall not be infringed. The legislature shall implement this section." The Article 1 of the California Constitution articulates privacy as an inalienable act. CASB 1386 expands on privacy law and guarantees that if a company exposes the California's citizens' sensitive information, this exposure must be reported to the citizen. And this law has inspired many states to come up with similar measures on that type of an issue of privacy, because it is a right. It's an inalienable right. California Constitution, Article 1, Declaration of Rights, Section 1. All men are by nature free and independent and have certain inalienable rights. Among those are enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety and happiness. All political power is inherent by the people. Government is instituted for the protection, security, and the benefit of all of the people, and they have the right to alter or reform the same whenever the public good may require it. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be generalized in the state, and no person shall be rendered incompetent or to be a witness or a juror on account of his opinions or matters of religious belief, but the liberty of conscience hereby secured shall not be construed to the excuse acts of licentiousness or justify practices inconsistent with the peace or safety of the state. The privilege of the writ of the habeas corpus shall not be suspended unless when there is in cases of rebellion or invasion The public safety may require its suspension. All persons shall be ballotable by the sufficient sureties, unless for capital offenses when the proof of evidence is the presumption great. Excessive bail shall not be required, nor excessive fines imposed, nor shall cruel and unusual punishments be inflicted. Witnesses shall not be unreasonably detained, nor confined in a room where criminals are actually imprisoned. The right of trial by jury shall be secured to all and remain inviolate. The limit in civil actions, 3/4 of the jury may render a verdict. A trial by jury may be waived in all criminal cases not amounting to the felony by the consent of both parties, expressed in open court, and in the civil actions by the consent of the parties, signified in such a manner that they should be prescribed by law. In civil courts, fine cases of a misdemeanor, the jury may consist of 12 or any number less than 12 upon the parties may agree in open court. And then offenses heretofore required to be persecuted by the indictment shall be persecuted by information after examining and commitment by the magistrate. By the indictment with the such examination and commitment as prescribed by law, and the grand jury shall be drawn and summoned at least once a year in each county. Sorry about that. There are many recognized and seen inalienable rights shown right there alone in the California Constitution.